My name is Pierre, and I'm joined by some wonderful attorneys, Attorney Yesh, Attorney Ashley, and Attorney John Veely. Thanks so much for being here with us. I know we have about 17 minutes for today's webinar, and would love to discuss E2s and L visas a little bit more. Why don't I give the mic over to John to give a quick introduction and tell us about what's happening in the world of immigration?
Thanks, Pierre. Appreciate it. Yeah, we'll jump right into L's and E2s, what they are, how to think about them. So these are good visas for investors and owners of international companies, people that want to move more than just themselves to the United States, but maybe they want to take their company and make it grow it from being a domestic company in their country to being an international company with locations both in their country and in the United States. That's the L. The E2 is an investor visa, but it's an non-immigrant visa, right? Meaning that it's chunks of time, but it can be extended as long as the company is viable. Viable means providing goods or services. Now, there's only 33 countries that have the E2, and it's interesting which ones do and which ones don't. Australia has it, New Zealand doesn't. None of the BRIC countries do. That's Brazil, Russia, India, or China. Really big populations. They don't have it. India doesn't, but Pakistan does, right? Interesting in that scenario, which do and which don't. So those are where individuals of that country can invest a substantial amount of money into a U.S. company, which often is theirs, but they must own 50% of that company, right? And that's the deal. So when we're looking at it, we're usually looking at one or other option when we're talking to somebody that says, hey, I want to come to America, I want to invest in a company. So we look at, are they an E2 country? That gives us two options. Or, do they have a company back home? That's the L1. Sometimes we compare the L1 to the E2. The L1 has a cleaner pathway to a green card. You can actually go from the E2 to the same green card you can for the L1, but many times you look at that at the beginning. So the green card that's similar to the L1 is the EB1-3 or EB1-C, and that's the multinational executive. And in those visas, both the L1 and the EB1-3, it's where somebody has held the job, and it's a job, right? Not just being a silent investor, but having an executive or a managerial job in the company for one full year in the last 3 years, and then transferring yourself over. So once that international company has existed for a year, so say you incorporate today, 1 year from today, you'd be able to go to an EB1-3, even though you may not get the visa on the L1 for some time within this year, right? So these are the sort of strategies that we give folks when they're thinking about that. Another similar one might be the EB5, which is the immigrant version of the green card version of the investor visa. But that's sort of a pathway that I think we could start from to bring in some discussion from Ashley, maybe.
Yeah, the L is a really good option because unlike the H, you don't have to go through the lottery. The only caveat, as John said, is that you do have to be working for an affiliated company or organization abroad for a year. So that's the thing that weeds some people out if they don't have that full year of experience with a affiliated company abroad. If they do, there's two pathways you can take with the L. There's the L1A, as John said, that's the manager executive. And that would be if your role is primarily managerial. You can be managing a team or personnel, or you can be managing a function of the organization. Functional managers tend to they're more closely scrutinized. That doesn't mean that they can't be approved, just that a certain amount of evidence is needed to get past that barrier. Personnel managers are a little bit easier, especially if you have more than one line of people below you. So you're not a first line manager. If you are a first line manager, then you would have to prove that the people that you manage are professionals, which means that they have at least a bachelor's degree. And then the other option is the L1B, and that's a specialized knowledge position. A lot of people that would like to do the H1B, but can't because they weren't selected in the lottery, that's a good option for them if they have that 1 year of work experience. So it's kind of a primer on L's.
Actually, I think that's great. If I can ask you a question, what documentation is usually needed to prove the skills and knowledge, specialized knowledge of a L1 applicant?
So specialized knowledge for L1B.
Yeah.
So the easiest way is if they're working on something that's proprietary to the company. So we would show that they have the specialized knowledge of the company's proprietary tools, processes, technology that wouldn't be easy for a U.S. worker to just step in and do that job, even with a little bit of training. Um, that's the easiest way. But there's other ways if they have advanced knowledge of a certain type of industry or the clients, then that can work.
And is
Anything
it
that they
usually
have.
the individual that applies for this, by the way? Sorry to cut you off. The individual or
So
the company?
the company is the petitioner, and then the individual would be the beneficiary. So it's the company that's applying on behalf of the person.
So one of the things that we often do in that for companies is ask them, do they have a training plan that lays out specifically in with documents that says, here's the secret sauce, right? And here's how we taught them the secret sauce, and here's how long it took them to learn this knowledge. So obviously, if it takes a year or more to learn this special knowledge, you have documentary evidence uh, that you've done this, and it takes a long time, so you can't just hire an American to do it. So many times we'll get in and they haven't documented. They put people through training. It's on the job training. They know this sort of stuff. So one of the sort of a lawyer tactic, right, is okay. Let's take what you've taught them, and let's put it into a documentary form, right? Let's create a training plan for you that you can take people in to do that. So that's one of the things, Pierre, that if they have is evidence, one, that it's specialized and how long it took them to learn that specialized process.
That's lovely. And in this case, John, your firm, or Ashley, your firm would be able to help with this training program, the making of it, if a petitioner doesn't have it yet.
For sure, or sometimes just documenting what they already have, right? Like, this is what we do, and things like that. You can create programs for them as long as it's authentic. I mean, that's the key, and they've really done it. That's, immigration's always about, is this real? But that's a way to memorialize something, so that they can do that. But yeah, that's what immigration lawyers can do, to help companies prove things to the government. And if you think about immigration in general, they don't tell me what it is, show me, right? So that's a show me piece of evidence right there.
How about when it comes to family independence? We spoke briefly about this, but if you're coming in on an L1, how does the process look like for your spouse and children?
Go ahead,
Your
Ashley.
spouse and children would get an L2, which is the dependent visa for an L1. L2s are cool because recently they now get automatic work authorization for the spouse, which is great. That's a huge benefit. So they can work, as soon as they get their visa and come in. Yeah, it's the same validity period as the L1, so you have to extend it or renew it at the same time.
It's fantastic. It's the spouse of the L1 almost has a de facto green card, right? I mean, they can go anywhere and work for anybody doing anything. It's a wonderful thing, and the E2 spouses get that as well, which is rare. So those aren't, every visa doesn't have that. The O1 for extraordinary ability, for example, spouses don't have the ability to work. H's spouses don't have the ability to work, with the small exception of H4s. That's the spouse visa for people who have filed green cards and had the I-140 approved and are waiting, right? So very, very narrow for H spouses to be able to. So L's and E's do have that, and that's a huge benefit.
And it's for children up to 21.
The
And then
other
they
cool
age
thing
out.
about L's, they can travel. L's and H's can travel during the pendency of a green card. O's can't, right? P's can't. ours can't, and that's really difficult. And the reason they can is because these are international companies, right? So if you're an executive in an international company, you're going to need to go in and out of the United States. So if you do have a pending green card, you can do that. For the other visas, if you file an adjustment of status, you can't leave until you get your what's called advance parole, which is a travel document, and that could take almost as long as the green card itself. Just months and months, sometimes over a year to get that part, and so that traps people in the United States. But those on L's can actually travel. E's can't though.
Caveat. While the I-131 or the advanced parole is pending, you should not leave, even though you can travel on your H&L visa, because they will consider it to be abandoned and then deny it.
Well, they'll abandon the 131.
Right. Your AOS application will be fine.
Right. Which
yeah.
is
and you can refile. You can refile the I-131, and when people have urgent travel and they have to leave and it gets denied, it's easy to refile it. But it used to not have an additional filing fee. Right. Now it does. Yeah. So that's a little bit of a.
So on that, actually, what would you do? So if somebody needs to travel, you just don't file the 131. Let them travel on.
Yeah, if they know that they're going to be traveling, I would hold off on filing that application until they get back. If something comes up,
status, right?
I would file the adjustment of status. I would file the I-765. I just would hold off on filing the I-131 until they get back. If they don't know that they're going to travel, if something comes up, somebody's ill and they have to travel, then I would say, if it's an emergency and you have to do it, go ahead. This will get denied, and that's okay. We'll refile it. There is a nominal refiling fee. I don't remember what it is off the top of my head. I think it's just a couple $100. And it's doable. They won't hold it against you the next time you file.
Up front though, or you're going to have a very scared client when they get his denial in the mail.
Yeah. And I've dealt with that before.
Yeah. Good point. Good discussion.
Yash is also with us. Yash, if you can hear us, do you want to give any insight into this? Is it your specialty, L's?
I don't handle a lot of L's, but I was going to add in that for the dependents, one of the I guess one of the strong points for the L2 is that you do get an EAD, but I think John's discussed that already.
Brilliant.
Yep.
Yeah, thanks for that, Yash. As we near the end of our session today, I know we covered L's pretty extensively on the requirements. When it comes to the job duties, what job duties or what details of your job usually are included in the description of these visas, Ashley and John? What specifics, how detailed do the descriptions have to be? Because you told me about the training.
Yeah.
But
so they want them to be pretty detailed. They want them to be detailed enough that they can determine if the job is primarily managerial or executive, or if it requires the use of specialized knowledge. Generally, they want percentages, the percentage of time that's dedicated to each duty, so they can kind of go through and determine what.
Is that common amongst other
very
visas?
common
I've never heard of
immigration, Pierre, because if 1% of what you do is executive and 99% is not, then you're not an executive. So what they're forcing you to do is break a job into components, say what each one of those components are, talk about how every one of those components is executive. And it's funny. I mean, immigration holds people in these jobs to a much higher standard than employers do, right? We all have jobs that do a lot of different things. Part of my job requires a law degree, but not all of it. Sometimes I'm a salesman, sometimes I'm a secretary. We do all sorts of stuff that's not related, but we got to break these jobs down as attorneys, where we take job descriptions from our employers and help, really translate that to a government agency that's trying to determine what that is. So one of the biggest things lawyers do is should do is not just take the job description the employer gives you and gives it to the government. It's really important for us to go in, because we know what the out of bounds lines are. We know what the regulations say. We know what the policies are. So we'll say, look, can you say it this way instead of that way, right? Because if you say it the way you're saying it, they're going to think this is not a managerial job. But if you say it this other way, is this also accurate, right? Yeah, that's still accurate. Okay, well, that's executive and the other isn't. So let's not focus on that one thing over here that might happen, doesn't typically happen, that's going to send them down that path and deny the case. So that's how that works.
And
Yeah,
Ashley,
and I
going
see
back,
that a lot with cases that are filed by other attorneys that maybe haven't filed a lot of L's, where they don't
Right.
put the percentages in and they just submit the job duties as they were, and then you get these massive RFEs that
Right.
then come to me, and then you gotta,
Yeah, we
you
inherited
know,
a lot of
play
cases
clean
at the
up.
RFE
Yeah.
stage where someone either tried it on their own or tried it with an attorney that either isn't an immigration attorney or isn't an immigration attorney with enough practice in the L space, and we see those mistakes there. And sometimes those we're hoping they're vague so we can add to it instead of so lined out that we're contradicting it, right?
Yeah.
And if you're contradicting it, you're gonna have to say, hey, this was some ineffective assistance of counsel, doing this.
Those are hard to overcome.
Yeah, and that's hard, right? That's really hard. Let me add one thing on employees too, because this is not seen anywhere in the regulations, but what we've just seen in our experiences is an executive has to have enough employees underneath them to be an executive. And a manager has to have enough employees underneath them to be a manager. So one of the toughest things, and what we see all the time, Ashley comes from a background where she was working with a lot of really big companies, and this wasn't an ever issue. Where I would deal with companies that are starting their whole entire American existence, and we're talking about it before they've started that. They want to come over. They want to get the visa first, and then they'll do it. I'm like, yeah, well, immigration is never going to approve an idea, right? Too many companies fail. So what you really need to do, though, takeaway, there's always nuggets in these sort of things. The nugget is you need to have at least 5 employees in a company before you transfer somebody over on an L. And why do you need 5? Well, you need to have an executive, you need to have a manager, and you need to have about 3 workers underneath that manager. If you have like one executive, one manager, and one worker, why do you need a manager, right? Manage one guy, tell me what he said or what she did, right? You don't need that, right? So 5 sort of the unwritten magic number to be big enough to have 3 tiers of employees. Tier 1 executive, tier 2 manager, and tier 3 frontline workers, right? And so that gets lost a lot. And when we inherit cases and they don't have enough. Now, there is a startup version of the L-1, but I find those are really hard to get approved, and I see them denied a lot. I've never had an L denied, right? And it's because I figured out what they want and what they don't want. And if you invest the money to open an office and you actually need to have a physical location with 5 employees there, they're not going to deny those visas because it's real, right? But if you try to say, well, I'm not going to lease a space until I get the visa, I've seen those denied, right? They may not do it all the time. They may let you do this, but it's really hard. And if you get away with getting one of those really narrow ones, you're probably going to get about a year, and then you better do everything. Now you're on the clock to hire those people. And I've seen people get those small ones and then not do that and then try to talk immigration into it a year later that they're going to do it now. Well, immigration's, we give you a shot. No thanks.
Yeah, that actually does happen with the bigger companies too, where they might manage a huge team abroad, but they don't have their team in the US yet.
Right.
And they would say, well, when she gets here, then we'll hire the team. And but for right now, she just has the one person below her. And it's like, well, that's not gonna work,
right? And
yeah.
So here's an interesting thing too. Because nobody wants to like hire and manage from a long way away from overseas. It's hard to do, right? So one of the things they can do is come on a B1, B2 to set up the company, right? Now, one of the things that happens sometimes is they come over on a B1, B2, they incorporate, they set up the company, they have a LinkedIn profile that says they have this company, and then they leave, right? And then they try to come back in and they get turned down because they're holding themselves out as their CEO of a company in America. That's not what a visitor gets to do, right? So if you come over, you can do it, but then move to the L or go overseas and then come back in on the L or D, right? But setting up a company in the United States, leaving the United States, and then trying to come back in as a visitor is a recipe for failure. We get those phone calls, unfortunately. Somebody from the airport or they're back home and they're like, "Oh my God, I can't believe this happened." And that's why they should talk to attorneys first before they try things like that. And they don't always do that.
Excellent. Very, very insightful. I know we're over our time, but one last question, if I could squeeze it in. If a foreign company is looking to establish an office in the US, do you guys see generally that it's a red flag if the US is its first foreign base? Or is it normal that, for example, if a company is based in the Netherlands and its first outside of the Netherlands base would be in the United States, is that a red flag? Or does immigration expect you to have multiple companies in other countries before you come to the US?
Go ahead, Ashley.
No, that's not a red flag. As long as you have the one qualifying company abroad in any other country, then it's not a problem if the US is your first other
I would say
international company.
almost all of my companies, not all of them, but almost all of my companies, their first international one is America, right? This is a great market. It's the American model, right, is to make something cheaper somewhere else and sell it here because Americans typically pay more for everything than anybody else does, right? So if you can make it cheaper there and sell it for more here, that's great, right? And so there's a lot of places you can make it cheaper for there and sell it for here, you know. And so, you know, not a problem
Brilliant.
whatsoever.
Love it. Ashley, do you have any closing remarks for today's session?
No, I would say get in contact with John or I if you've worked for a company for a year in the last 3 years abroad, and there's a qualifying U.S. organization, or you're looking to set one up. John has a lot of experience with setting those up. Uh, so yeah, it's a great visa.
Brilliant. Over to you, John.
Yeah, it's one of my favorites. I think the L1 might be my favorite visa because there's no cap on them. There's no prevailing wage on them. You get to run your own company. You know, so a lot of the immigrants are entrepreneurs for a lot of reasons, but one of them is it's hard to come over and get a job, right? As an immigrant, create your own job. You know, believe in yourself, believe in your ability to set your own company up. I really enjoy having conversations with people that are coming up with the idea. What if I brought my company to America? What if I started something in America? And I love how many people have become so successful that I've been honored to have the right to work with on that. And some of them have really created some fantastic companies that have done very well and have done. Some of them do lots of different companies. I'm thinking of a guy right now that probably created over 100 companies in America, has employed hundreds and thousands of people in our country. He's an Irishman and a good friend, and it's amazing how much he's done since he showed up. What's now 20 something years ago. You know, it's pretty cool.
That's brilliant. Thank you, John. Thank you, Ashley. Just for everyone watching, how can they reach you, John? We do have a shared screen right now with
Yeah,
two
right there.
emails. Is that the best way?
Yeah, information at vlilaw.com. Come to our websites, onlinevisas.com, vlilaw.com. You know, that's the best way for sure.
Brilliant. Okay. Thank you so much. And then for all the comments, we will address any comment next week. So please tune in next week, Friday at the same time, 12:30 p.m. Eastern, for another conversation with Attorney John Veely, and hopefully Attorney Ashley can join us as well.
I will be
Uh,
there.
awesome. Thank you so much.